Today's video aims to deal with the provision of addition of inventors in patent applications under the Indian Patents Act. Of late, I've been receiving queries regarding how to add inventors in a patent application, and as a result, I started reading about the provision and also read about the provision on the internet. And there are various approaches that have been suggested. Some of the articles suggest that addition of inventor under section 28 of the Patents Act is only to add the name of the inventor in the patent certificate. So let us now explore whether this is the case or what does the provision related to addition of inventors encompass. So before we go into the provisions, let us first see what are the situations that warrant addition of inventors. So maybe the first situation could be where you are converting your provisional application to complete specification. So there may be some additional contribution by new inventors. So when you filed a provisional application, it was only in the concept stage, and then few other inventors came through and they developed the invention so as to give it the final form for which you have filed the complete specification. So obviously they would like to claim their rights also on the additions that they have made. So if you are converting the provisional specification to the complete specification, the additional inventors could be added at that time. Also, sometimes it may happen that there is a late recognition of a contribution that has been made by a person regarding the development of the invention. So someone came to know about it at a very later stage that this person was also one of the inventors or a person who contributed towards development of a particular invention, and then you may want to add that particular person's name in the list of inventors. Also, it may happen that some person may dispute the fact that his name has not been included in the name of inventors even though he contributed to the invention, and thus he may also want to add his name in the list of inventors, and the provisions under the Patents Act provide him with an opportunity to get his name added in the patent as one of the inventors. So let us now go through what are the provisions that are available by way of which a name of inventor could be added to the list of inventors already existing in the records of the patent office. So first of all, let's see section 10(6). The section provides that a declaration to inventorship is required to be filed along with the complete specification or within 1 month of filing of the complete specification as per rule 13 sub rule 6. So this provision takes care of the aspect which I was referring to, the first situation wherein there has been some additional contribution made by an additional person in respect of the invention that was filed in the provisional specification. So now you have added some more material. It was conceptualized by someone else and developed the invention in its final form, which was being filed in the complete specification. So if you filed a provisional application with say 5 inventors and now there is an additional inventor that has contributed to the invention, you have the option of adding the name of the 6th inventor into the list at the time of filing the complete specification. So you file a form 5 where you mention the list of all the 6 inventors. So if you closely see the format of the form 5 that has been provided under the Indian Patents Rule, paragraph 4 has a statement which is to be signed by any additional inventor which was not mentioned in the application form. So when you are filing a provisional specification, you filed a application form listing out say 5 inventors, and then at the time of the complete specification you have a name of an additional inventor to be added. So you file a form 5 with the name of all the inventors, and the 6th inventor signs this declaration or statement which has been given under paragraph 4 of the form 5. So this is how you add inventors when converting your provisional specification to the complete specification. Another provision for adding of inventors is provided under section 28, which provides for mention of inventor as such in the patent, and I believe this wording as such is the cause of confusion because of which some people believe that this only enables the name of the inventor to be mentioned as such in the patent certificate that is issued. So let us see whether that is the case. And before I go into the procedure for adding inventor under section 28, I want to mention that this provision is for addition of inventor at a later stage. Once you have already filed the complete specification and you don't have the option of filing a revised form 5, then you go ahead with this provision so as to add any additional person as the inventor. So section 28 subsection 2 provides that a request for addition of inventor has to be made by the applicant or the applicant and the person who is intended to be added as the inventor if that person is not the applicant. This request is made on form 8 along with the official fee, which could be INR 800, 2000, 4000 depending on the type of entity which is filing the request. The provision provides that before the name of the person could be added as the inventor, inventor. The controller has to satisfy himself that the intended inventor made contribution to the invention or a substantial part thereof, and the patent application is a direct consequence of him being the inventor. So in a way, he contributed towards the innovation, and that particular innovation is being covered in the patent application, and relevant facts and evidence regarding this particular aspect may have to be provided by the additional inventor or the applicant so as to help the controller satisfy himself that all these conditions are met. Section 28 subsection 3 takes care of a situation where the inventorship of a person is in dispute. So in case the applicant is not willing to add the name of that particular person who claims to be the inventor, then a request could also be filed by that additional person because he is not covered under section 28(2). So the applicant is not filing a request on his behalf. He can file a request all by himself, and that request is to be made on form 8 along with the fee, and also he has to submit a statement of claim wherein he brings out the facts and circumstances related to his inventorship. Also, he may have to provide the relevant evidence in respect of that. Upon receiving such a request, the controller sends the statement of claim to the applicant of the patent application and also all stakeholders in the patent application. So before deciding such an application for addition of inventor, the controller has to hear both the claimant as well as the persons who are on notice, and then decide whether the name of the additional person could be added as the inventor or not. An important aspect about the requests under section 28 is that you can only make this request before the grant of the patent. So once the patent has been granted, you cannot make a request for addition of inventors, and this is provided under section 28 subsection 4. Section 28 also provides for provisions to rectify the records so as to remove name of any person who has been added as an inventor under section 28. So if the name of a person has been added by following the procedure under section 28, another person could also make a request so as to get this name of additional person removed. This is provided under section 28 subsection 7. A request in this respect is to be made on form 8 along with the requisite fee and also a statement of claim which specifies the facts and circumstances regarding the request, why that request is being moved, and what is the relevant evidence in respect of that. Again, the statement of claim is sent by the controller to the notice of the applicant or the stakeholders in the patent and also the person whose name has been added. And after hearing the claimant as well as the persons who are on notice, the controller decides whether the name of that particular person who has been added should be removed from the records. So you might have noticed that a principle of natural justice is followed even when the name of a person is being added or where the name of a person already added is being removed. So all persons are given a chance to put across their case. So Rule 69 of the patent rules provides the procedure that has to be applied for the purpose of hearing in respect of the notice on statement of claims. So it says that the Rule 55A and 57 to 63, which pertains to the notice of opposition or the pre-grant and post-grant oppositions, the same process needs to be followed while deciding any application under section 20A. So this means that there is a specific timeline for filing the statement of claims and evidence, and then a reply statement by the opposing side plus evidence, and then the first side is given the chance to file a reply evidence, and then a hearing is appointed by giving not less than 10 days notice to both the sides. So far we have only seen what are the legal provisions that are there in the Patents Act, but have we answered the question whether it provides for addition of inventor's name only in the patent certificate? For that, I think we need to look into the legislative intent. Before that, I'd like to say that in my opinion, that is a very restrictive reading. This provision helps to add the name of the inventor in the entire records of the patent application or the patent so as to recognize that person as the innovator for that particular invention. So the provision of addition of inventor finds reference in Justice Iyengar Committee report of 1959, and it recognizes that any person has a moral right to be named as the inventor in respect of a patent application. So even though he may not be able to derive any economic benefit out of the patent application or the innovation or commercialization of that, because he may have assigned his rights to his employer, but he has the right to be named as the inventor so that it gives him a mental satisfaction and gives him a prestige and helps to increase his economic worth. So how does that happen? Because his name is added in the patent application and patent applications are published, so people would get to know that this is a person who is an innovator, and thus his economic worth would increase in the society or in the relevant technical field. So neither the Iyengar Committee report nor the Patents Act specifically mentions that this provision only helps the name of the additional person to be added in the patent certificate. So I think that is a very restrictive reading of the provision, and nothing like that is actually intended by the legislature. So finally, to conclude, what the provision finally does is it helps you to add the name of an additional person who has contributed towards the innovation in the records of the patent office, and you can add that name, that person's name, in respect of the patent application. So this is all I had in respect of addition of inventors in patent applications. In case you have any specific comments regarding what I have opined, you can add your comments in the comments box and I'll be happy to address those. So over the time, in case I make any amends to this opinion, I'll make the changes in the description section, so please do watch out for that. Refer to the description section always whenever you watch this video, because it is not possible to amend the video at times, so I'll be making all those edits in the description section. I hope you liked the video. As I said, in case there are any questions or any comments, please drop them in the comments box. Thank you very much for your time.